Page 41.
We are live.
Oh, yeah. Okay, this is Thursday, September.
I'm not.
This is Thursday, February 16th, 2023. Matt Valerio came in and I thought it was late September.
Oh, 2014 today.
Yeah. So we are taking up an act relating to reducing the imposition of cash bail, I believe just for misdemeanors. So we should title that, by the way. It's just misdemeanors.
Yes.
So, our first witness is Michelle Childs, legislative counsel who drafted the bill, and it's a walkthrough.
Good morning.
Nice to see you.
Nice to see you. So for the record, Michelle Childs, Office of Legislative Counsel. And I'm gonna share my screen. All right. So Senator Sears is correct. We're talking about cash bail as it relates to misdemeanor. So we're working in Title 13 in the chapter that addresses bail. I'll move down to the amended language here. So you'll see in subsection B, there's some limitations on the imposition of bail. I will note that in B1, I would need to make just a little technical change there because it says that it's except as provided in subdivision 2, and we strike subdivision 2. So you'll see there is the exception is that there's no bail to be imposed in subdivision 1 at the initial appearance of a person who's charged with a misdemeanor if the person was cited for an offense in accordance with Rule 3. And I think you guys have been working on another bill recently that implicated Rule 3, so you're pretty familiar with that. So if the person received essentially a ticket rather than being arrested, then they can't, then you don't set bail. Subdivision B starts with the changed language, which is at the initial appearance, a person charged with, right now it says, a violation of a misdemeanor offense that is expungible, eligible for expungement. And I can switch over after I just walk through the bill here and just show you kind of a little bit of reminder about what types of misdemeanors are expungible under your current law. And then you'll see in subdivision 2, there's currently a provision that says that if the court finds that imposing bail is necessary to mitigate the risk of flight for prosecution, remember there's 2 provisions in setting conditions for release. There's mitigating the risk of flight, and then there's the provision around protecting a witness or for public safety reasons. You can only impose bail in circumstances when it's to address mitigation of risk of flight, not for the public safety piece. And so, you did change for Senator Sears will remember it was several years ago that you changed it around the language. Now it says that it's to mitigate risk of flight. It used to say around, assuring appearance of the defendant. And so right now is that there is the ability to impose bail in an amount of up to $200 in those types of cases if the court believes that is important in reducing the risk of flight. And so this is eliminating that. So what you have in A is in subdivision 1B, is it's changing it from the types of cases that you don't set bail. It's going from just those misdemeanors that are expungible to all misdemeanors. And then it's striking subdivision 2, which is the allowance for the $200 in those circumstances where it has to, where for misdemeanors where there is a risk of flight.
So, just trying to understand.
Sure.
So it basically eliminates cash bail for every misdemeanor.
For misdemeanors.
Everyone.
Mm-hmm.
No matter what the offense is.
Correct.
Thank you.
Can you just define for me what a risk of flight is? Because I know there's, actually, I'll just leave it at that. Could you define risk of flight for us?
I think that'd probably be a better question for the witnesses, but particularly with the court about how they're assessing the termination. I mean, I think they're gonna look at the history. Has someone failed, have a history of failure to appear, or there've been conditions set in the past and they haven't adhered to conditions. But I think the witnesses can probably give you better examples of that.
Sounds good, thank you.
So section 2 is a directive to the Attorney General's office, Defender General's office, state's attorneys, judiciary, Center for Victim Services, and then networks to work together to identify the conditions that would be required to move towards the elimination of the use of cash bail for the purpose of mitigating risk of flight, and they're to develop a proposal to eliminate cash bail in Vermont, and to report their findings to the General Assembly by December 1st of this year.
That working group would be to completely eliminate cash bail. So
Yes.
Okay.
For every crime?
It isn't limited in here. No limit.
Just could still hold without bail.
Yes, for violent crimes, correct. Section 3 is requiring the Department of Corrections to collect race data on pretrial
Can
detainees.
you check with Ben? I think we're doing that in S14.
Okay, sure.
Just make sure that we don't,
The data collection.
yeah, and if we're not, we should probably put that in S14 and not in this bill. Because that's all about the
Sure.
Yeah.
data collection.
Um,
I have no opposition to the date, I just don't want to do it twice or have it confusing and using different terms.
So section 4, this is a directive to the judiciary, and the intent is to try and reduce the instances of failure to appear by folks who are charged with criminal offense. And so on or before July 1st of 2025, the judiciary is to establish and implement a system to electronically notify folks that they have an upcoming court appearance. And then you'll see in subsection B, on or before December 1st of this year, the judiciary is to report to the General Assembly any requests for legislation or money that they would need in order to be able to fund the system, to be able to notify defendants. And then subsection C is on or before December 1st, 2026, the judiciary is to report back to the General Assembly on the efficacy of the notification system.
Quick question.
Sure.
Just as you probably don't know, Michelle, at this point. What would this look like, just in your opinion?
Again, I think we probably talked with Judge Zone about that, but I know in talking with the sponsors, because this bill is, I think it was introduced last biennium, and I think in working with the sponsors at that time, the issue was, sometimes people forget, what can they do to try to make sure that resources aren't being wasted, court time, attorney's time, having to reschedule, but how can there be a system to help people basically get it together to be able to show up at the court appearances. And I think people have talked about, a text system that goes out to folks. So, but I don't know what type of technology or how they would go about that.
Text message. Well, maybe they can expand upon it, so.
Sure.
Do it, those.
And so sections 2 and 4 take effect on 2 through 4 take effect on passage, and section 1, which is the changes to cash bail, they don't take effect until July 1st of 2025. And so, so that works together with your earlier piece around the stakeholders getting together and coming back to the General Assembly with recommendations on how to approach the elimination of cash bail. And so that has a much later effective date for the changes that are being proposed in section 1.
Under the, if this were to be the law, could someone who commits an act of domestic violence, because it's a violent act, still be held without bail, or would they, because it's not a felony, be released?
I think you could only in that circumstance probably set conditions that are already in statute. But
what can, you can set conditions, but how do you enforce the conditions? You can't.
if they violate the conditions,
Then you could.
then you can pull them back in.
But you couldn't put them in. You couldn't hold unless you contempt the court, I guess.
I don't know, I would.
I mean, I think that's an important issue, at least for me, is to understand, because there are violent acts. Yes.
I was just gonna speak to this point. Yeah, I'd like to hear more about it from the court and other witnesses, but in domestic violence cases that I investigated, often people would be held, they'd be flash cited, so they'd go to jail for a night, maybe 2 nights if it was a Friday. And then, so they'd be held for a couple of days. So that's, and regardless of, where they live. So I think maybe that's something we could ask more questions about.
My understanding, and Michelle certainly correct me if I'm wrong, of the permit bail statute is you can't use bail to hold someone because you think they're violent.
Correct.
You can only use bail as a means of trying to get them to return. So in our current system, we can't use bail to hold someone.
Right. So,
Oh, thank you so much.
Further out there.
But I'm,
Like
but you can hold without bail a felony
Correct,
if you, if the person, if the weight of evidence is great, and if the person has maybe a danger to somebody else.
correct.
I think those are the standards. I'm asking if in the misdemeanor, you can't do that with misdemeanor, you can't do that right now with misdemeanor domestic violence.
You can't hold without bail,
Okay.
correct.
But that's not changing because of this bill.
Right. They're always gonna pop up that statute. I'm a little slow on Zoom. So there's this section that you were speaking of, Senator Sears.
Yeah, I think, I mean, I suppose, I would
You got
guess
all the
that,
elements right off the top of your head, so.
well, I think that's probably the largest criminal offense that would be eliminated from cash bail here.
So I will also just, if it's helpful, show
When the
you,
prosecutors come up, I'll ask if they'll just increase the charge to felony.
With the chat.
here's here's the qualifying crimes. So you can see right now, this is under the expungement statute.
Mhm.
So right now, the ones that are currently prohibited from setting the cash bail are these, it's kind of like all misdemeanors except listed crimes, sexual exploitation of children, violation of an APO, prostitution, or a predicate offense.
So if someone in a misdemeanor domestic violence case, part of their conditions was an order of protection and they violated that, they would then be able to be held without bail?
Then you could impose bail.
Okay. But you can't impose bail as a means of
Right, bail's only, like as you said before, it's only to mitigate risk of flight.
I have another question that is not related to this, but my understanding is Illinois has eliminated cash bail. Do you have any idea when that law went into effect?
I do not, definitely in the last few years, but again, you know, witnesses might be able to give some more details on that. And, or I can follow up while the witnesses are testifying. And I'm just gonna pop up the statute for setting conditions so that you can have a little reminder of what those are. So here's our statute for release prior to trial. So you see on subdivision A1 is around mitigating risk of flight. And so here are a variety of conditions. So I think Senator Sears, you had mentioned something around the defendant being placed into custody of as a designated person or an organization, placing restrictions on travel or association for the defendant, requiring the defendant to participate in the alcohol or drug treatment program as long as the court considers the feasibility of that person, either financially or logistically being able to comply with that. Subdivision D is the requirement of bond. Subdivision E, cash bail. Subdivision F is just kind of the catch-all of any other conditions that are reasonable to mitigate risk of flight. And then also remembering there's a requirement that it always be the least restrictive set of conditions when you're setting that to accomplish the goal.
This may be a better question for the court, but do you know if in the feasibility of alcohol or substance use treatment, if they have to take into account the availability of that? I mean, we know that there's wait lists and a lack of providers.
Right. Well, I would look at if you say right there, and the availability of treatment resources right there.
It is right there.
Great question.
Well, it would have been a better question if it wasn't right in front of
It's
me.
okay. There's a lot of.
Okay. Any other questions for Michelle? If there are none, I think we'll start with Roy Thibault, who is state's attorney, former Washington County State's attorney, and currently freelancing. Is that a good way to put it?
It is, Senator.
Well, we welcome you here. Thanks for coming in and talking about this bill.
Thank you very much. So, up until the beginning of the month, I was the state's attorney for Washington County, and now I am the responsible adult for Mr. Leader's Dumont as the same as the sheriff. With that said, I want to open by briefly just saying that in its current form, the Department of State's Attorneys and Sheriffs does not support the bill as drafted. And I'll go through some of those concerns, some of which the committee has already noted in its discussion. Might go in reverse order or leave the first section 1 from last week. That's going to be the most discussion. With respect to section 2, the department has no objection to the study being continued, but we would note that there are already a number of standing boards and committees that deal with either similar issues or other issues, and convening a separate body for this may really force many of the same stakeholders into yet another grouping or organization. I'm sure Mr. Blair could probably say that there's some degree of, I won't say exhaustion, but there's a lot of commitment on the same group of stakeholders on some of these. We'd also recommend that the Department of Corrections be added as a participant, given the legislature's recent removal of authority for things like pretrial detention of the home detention program, which formally allowed bail to be suspended and use of GPS monitoring by the Department of Corrections. That authority lapsed, I think, several years ago. But those may be among the alternatives or other ideas that will come up for discussion. And obviously, we think the Department of Corrections Corrections is a stakeholder that should be part of that conversation. With respect to section 3, we take really no position. The Department of Corrections already collects the data. It's just probably a function of how that's transmitted or made available to the General Assembly. And with respect to section 4, we're not opposed to any investigation of means by which there can be electronic notification to vendors or participants in the court system. The only reservation we have is this. Already, most individuals that come to court are admonished or given specific conditions to maintain accurate residence, phone, and other contact information with the court. In Washington County, my experience was defense counsel were generally well prepared, made earnest efforts to stay in contact with their clients, but sometimes couldn't because phone numbers were changed and there was then no contact or no effort made to update the court or their counsel with that information. So inherently, there's always, from our perspective, there will always be some issue or really effort needed by the person basically charged to make that work. Turning, of course, to the more substantive portion here with section 1, the department's view is that cash bail remains a needed tool to ensure appearance in limited circumstances and limited cases. Our concerns as a department really are centered around listed misdemeanor offenses. And just to give an example, not only is domestic assault a violation of the prevention order, stalking charges, reckless endangerment, and additionally, at least one non-listed misdemeanor jumps out as being fairly important, which is criminal threatening. Since the question's been asked, it's probably important to review what a court considers when deciding to impose cash bail or not. And really, for purposes of what we're striking here, we're looking at those temporary release situations or after-hours calls to a judge for seeking bail when there is a risk of flight. And Senator Mahowski is absolutely correct. Bail is not a tool to incapacitate someone because they pose a risk of violence or because they're an annoyance in the community. It is reserved only to deal with their appearance or risk of flight in a court setting. So courts consider this when, and this is coming straight from Title 13, I think 7454. Courts consider the following factors: the seriousness and number of offenses, the nature and circumstance of the offenses charged, the weight of the evidence against the accused employment, financial resources, including the accused's ability to post bail, prior failure to appear, record of convictions, character and mental condition of the accused, the length of residence in the community, and the record of appearance at court proceedings for flight to avoid prosecution previously. When a law enforcement officer calls for bail or setting bail or conditions overnight or after hours, there's really a two-step process that occurs under Rule 3. There's going to be contact with the prosecutor to get a recommendation as to what those bail and conditions are, and there's going to be a call to the judge. The judge will make a determination as to whether there's probable cause for the alleged offenses, and then from there, the next step is an articulation by the arresting officer, trooper, or deputy sheriff about what is being sought. And frequently, those will involve no contact conditions in the context of domestic assault, not to abuse or harass, maybe to vacate a premises. But there are circumstances, of course, where flight risk is real. Someone in a relationship who has no ties to Vermont, who's visiting from, say, New York or an out-of-state area where there is no reason for them to potentially stay. And in those cases, we do see courts sometimes exercise bail. The officer is also obliged to provide the background check as they can. At a minimum, that's going to include a Vermont record check. And then frequently, when it's individuals out of state ties, they'll pull up what's called triple I, so an interstate index of past offenses. And in there may be a history of prior convictions and the prior non-appearances that can inform a court of which way to go. One of the other things we wanted to set the table for, and we did provide a supplement that can be reviewed after this. Mr. Leaders Dumont worked with the Department of Corrections to really try to get an understanding of what is the size and scope of our current misdemeanor population held or detained pending trial in the court system. And as of the 31st of December 2022, 34 of 428, or 8% of individuals who were detained pre-trial were being held for a misdemeanor offense. And of that 34, more than 3/4 were for a crime against a person. And DOC lists that under their classification as misdemeanor domestic assault or simple assault. That leaves about 9 8 or 9 other individuals who were held for various reasons. The data available didn't show how long they were held or break out whether they were held upon initial arraignment or whether they're held subsequently for non-appearance or being arrested on a warrant later in the process. DOC also provided us with a snapshot of data accurate and up to date as of yesterday, which shows that the grand total population right now held on all forms of bail, including being held without, is 445 individuals. Presently, only 19 of those individuals are held on a bail amount of less than $1,000. So that presumably captures right now the individuals who are being held for some form of misdemeanor. There's one other number that is interesting and leads to a sort of side conversation of all this, which is when we begin exploring what are alternatives to using cash bail. There are 34 individuals who are currently in Department of Corrections custody for various reasons where they're listed as being held with zero bail. DOC wasn't able to articulate in detail who those people were or why, but the one area in which they said that would classify as when people are held for lack of a responsible adult. I think many of you know my former colleague and the current Chittenden County State's Attorney has a policy of herself and her deputies not asking for cash bail. In lieu of that, they are attempting to exhaust other alternatives, whether conditions or use of responsible adult to compel individuals who come to court. Courts nevertheless still impose cash bail even when not requested by the prosecutor based upon those factors that were referenced. The overall use of the responsible adult as a mechanism to assure appearance is one that is not without its own problems because it can serve or act as a de facto hold without bail when someone cannot find someone to stand up for them or bring them to their home or have them. So that really brings us full circle to the baseline concern, which is to move forward to eliminate cash bail further in these circumstances would eliminate a unfortunately necessary tool at this point in time without a meaningful alternative in place to compel or assist in getting people to court. In the back of our materials, we did provide a hypothetical vignette centered around a domestic violence incident, and I won't go through all of that now to save time for questions, but it really goes through a hypothetical of if cash bail is eliminated, what to do with someone who commits domestic assault with out-of-state ties, was apprehended out of state, brought back, and then doesn't come back again. And the question really is, what do you do in the absence of that, or is there a mechanism which, once someone has exhausted several efforts of not having cash bail, that it could be used or some other mechanism in place to ensure justice and safety for victims? So with that, I'm happy to take questions from the committee.
Would the sentencing commission be the better alternative?
The sentencing commission is
I'm talking about section 2 now.
I think would you have a number of stakeholders there, the judicial participants, the Department of Corrections party to it, the Attorney General's party, Department of Children and Families there to the extent that they have any interest for the potential overlap for juvenile and federal proceedings. So.
Are you aware of the statistics, and I'm not going to get them exactly right, that people held even for just a couple of days pre-trial in jail are far more likely to commit another crime?
Well, that's the only counter I have to that is that it's difficult because the reason someone's held in bail in the first place is typically because of past record or a history of non-appearance. And from my experience, and I've had a number, I think 5 different judges rotated through my time there, even before the current bail reform or the current statute was in place, the use of bail in misdemeanor cases was incredibly sparing. The law has changed to ban the imposition of bail when someone appears on citation was really just codifying existing practice. When someone voluntarily shows up, courts are loath to hold somebody. And I really do view that most judges at this point would exercise it as a last resort. And the type of cases we're seeing held in bail, maybe the after hours domestic with someone with loose ties, or when we start dealing with other general crimes, it's because it's their 7th, 8th, 9th, and 10th case, and in those other procedural dockets, it's a history of non-appearance. On my way out of office, I tried really hard to help clear our backlog, and we had about a dozen cases involving individuals who had, over the past 3 to 4 years, accumulated anywhere between 10 to 15 different dockets. Some of that's violation of conditions of release, And in many of those cases, we just released they don't make contact with their defense counsel because they're arraigned out of county and there's no progress and they still don't feel compelled to come to court until a judge eventually decides that on whatever docket's before them, $200 bail or after hours hold somebody just because of problems caused. So the statistic may be valid, but there may be also other causation to that, which is you're dealing with a population that already has, or is more likely to have a greater record than the average.
Well, and the statistic also does show that even people being charged for the first time are much more likely to commit another crime when they have been held even for just a couple of days pre-trial.
I guess the only counter question I have to that is that limited to analysis of Vermont offenders, or is it looking at a nationwide? And I think that Vermont, for really a longer period of time than any other counter stances, moved away from the idea of bail as some sort of de facto presence. I think the old school model of thinking was that some amount of bail was needed based upon the offense being serious or there being collateral consequences attached to it. And certainly pop culture and society has propagated the idea that when someone does something wrong, they're held in bail. That has not been reality in Vermont for over a generation. And increasingly, probably not at the rate everyone would like to see, but we have seen a lot more misdemeanors on first impression being sent to diversion and not even considered for the pipeline of bail. And with that said, most of our misdemeanor cases are still at this point coming in on a citation, not a flashlight or an emergency arrest. We do that in one other statistic that's I think notable is right now we have 19 individuals or so that are held in less than $1,000 bail for FY21. There were nearly 12,000 total criminal cases filed and over 9,100 of those were misdemeanors. So we're dealing with an incredibly small percentage of those individuals, which does harken back to the Department's position that it's a necessary tool in a narrow set of cases.
Several years ago, Bill Young and John Terry, who used to, Bill was former commissioner of DC out, and John was working for the Department of Corrections. They did a study, and I think their focus was mainly on substance abuse. Those that went to jail were less likely to be successful with and more likely to commit crimes. But it's obviously based on Vermont inmates. It's probably what, 5 years old now?
Oh, geez, I think it's older than that at this point. John Perry's been gone for a while. He did it, I think, the summer that he left.
John's still alive though.
Yeah, oh no, I
When
contacted.
you said he's gone, I don't.
No, not from DOC. I didn't contact John regularly, so.
Anyway, I guess one good point of that with that particular population, the data that the Department of Corrections provided at the end of the year showed only one person being held on any amount of bail for a misdemeanor drug offense in the whole state. So I think that's a good sign. And I think does demonstrate that in practice, it's typically the more serious misdemeanor cases involving some sort of harm against a person that are drawing the attention or where court in determining that the weight of the evidence or likely outcome warrants that. And from my experience, I think domestic assault and violation of abuse prevention orders are contentious cases. There's a lot at stake for an offender, and even though the misdemeanor, there are collateral consequences, including forfeiture or loss of privilege to own and possess firearms, and that can be a really powerful motivator for individuals to try to avoid justice or disposition that upends. Right.
Thank you. All right, next witness. There it is. Matt Valerio, Attorney General.
Good morning, I'm Matt Valerio, Attorney General. I agree with about 90% of what Rory testified about, but I think it's obviously a shading of this that, when you look at the bill, I'm not totally hot on the bill myself for different reasons. Go through as Rory did similarly. I don't have a problem with the study committee, but I perhaps would suggest that the bill direct an existing organization or group to do it as opposed to creating another group. And that some of the folks who are here, who are listed on this be directed by, for example, the Sentencing Commission or the like to take evidence or testimony from the various folks who are who might be stakeholders under this rule. And really, I guess I'm talking about the probably the victims groups to the extent that they're not already part of the Sentencing Commission. I have no problem with section 3. The notice of hearings part is interesting. I'm not, obviously I can't speak for the court, maybe they'd love to do this, but I'm guessing not. We have a hard enough time keeping track of our clients. But the Defender General's office is putting in a new case management system that'll go live July 1st, and part of the added functionality of that is we're able to send text messages to clients for notice of hearings from our case management system. So it'll keep track of whether a message went out and to the last cell phone that we have. Of course, and remember, we do represent 90% of the people in court who have lawyers. There's about 10% of people who are pro se and 5% are represented by the private bar. So there's 10% that may benefit from what was suggested in section 4. I will say that our clients are, by definition, indigent. They move around a lot. Many of them are homeless. Many of them don't read well. But a lot of them do have phones, and maybe it's not the same phone. Maybe they're burner phones, disposable phones, that kind of thing. This is one of the difficult things that we deal with in the system is keeping track of people, where they are, how to get a hold of them. And it's going to be the next couple of years going forward. We're going to see, I think, a lot of people have disappeared since the beginning of 2020, particularly misdemeanor cases where, honestly, we don't know where they are. And I don't know how to get a hold of them. We don't know how to get a hold of them. There are a lot of people who actually came to Vermont during the pandemic seeking sort of green asylum from the virus. And then when the pandemic kind of spread everywhere, and as things have become endemic, they've gone on their way to other places. These aren't it's just folks who move around a lot. So I don't see this as a problem. I think it might be a good supplement. I am always wary of the court's technical ability to accomplish these kinds of things. I'm also wary of our technical ability to accomplish these kinds of things. I think we have our system, what we're going to do voluntarily, I think is going to be more effective. But if you want to give it a shot. Back to, I guess, the substance of the bill. I think Rory's correct that currently very few people are held on bail for misdemeanors. Almost none, and those that are probably shouldn't be. They shouldn't be for even some of the reasons that Rory talked about during his discussion. Domestic violence cases, and the like. The analysis for purposes of bail for a misdemeanor domestic violence charge is no different than any other misdemeanor. So you're not holding somebody on bail because of their alleged dangerousness or the like. That's not part of the analysis for a misdemeanor. So it's kind of a red herring to look at 7554 as part of an analysis, because that only applies to felonies. So that's really not what we're talking about here at all. And I think that one of the things you'll find for people who are held on misdemeanors currently is it's people who are on some other form of, they're on probation, or they're on parole, or they're on furlough. And we see that a fair amount. People come in with a new misdemeanor, and they don't have a right to bail under those circumstances, but they sometimes get held on small amounts of bail. Nonetheless, we do have an issue in Vermont where some prosecutors honestly don't understand bail, and they pursue bail in cases where it's not appropriate. And there are some number of judges who don't understand bail, and they impose bail in circumstances when it's not appropriate. And we do a fair number of bail appeals through the appellate division of the DG's office, and we almost always win them. It's like 99% of them end up being overturned. It's not. It is not the kind of thing that is kind of in a common understanding sense. It's not commonly understood. They expect if somebody's going to be arrested that they're going to be held on bail. But that is not what Vermont's bail statute says.
Yeah, do you have an idea of on average how many bail appeals you're doing a year?
A couple a month. I think we're also missing a fair number of them. There might be some strategy also going on with defense counsel regarding doing a bail appeal or not. Doing a bail appeal it happens quickly. It's kind of a pain in the butt. It's a fair amount of work in a short amount of time. And by the time you get it done, a misdemeanor might be resolvable for time served or probation or the like. It's usually if you have multiple misdemeanors that arise where the jeopardy, if they're stacked together, it could be a longer period of time where it makes more sense. That kind of thing. We do, I'm guessing we do a couple dozen a year.
And it sounds like that's a relatively burdensome process.
The process per case is burdensome, but overall, we do the system is 22,000 cases a year, so I'm not really worried about the 24. It's just one of those things. It's kind of a pain in the butt. That's all. It's because most of them are quite obvious. Judge didn't follow the law and impose bail when they shouldn't. If we look at it and the analysis is, the judge appropriately imposed bail, we aren't going to appeal it. So that, it's when you do appeals like that, it's there's definite kind of cherry picking going on. You're only going to appeal the ones you can win, and oftentimes we see it with the same few judges over and over and over a couple of years. I think some of it is they don't like the way the bail laws are written, and they want to do something different, and then some may not just quite understand it. We do see in some offices where state's attorneys have turned over, you get a lot of new people in all at once, that there's not really an understanding of the bail laws from some of the state's attorneys' point of view. And even, defenders who go in, the brand new ones, and particularly ones who come from out of state, because we don't really get many who are anymore who are like right out of law school becoming public defenders. But we get people who practice law in other states who come in and they aren't familiar with Vermont's bail law. They will rely on what they knew before, where bail is more likely to be imposed. One of the things I am concerned about regarding this is the suggestion that Senator Sears made, which is upcharging offenses where it's possible. There's some number of misdemeanors that are, have an element of violence. It's not just domestic assault, it could be simple assault. It could be the criminal threatening. It could be reckless endangerment. It could be any number of things that look violent, but they're, maybe charged as misdemeanors, but they could also be charged as felonies. I would be concerned that some prosecutors might take the opportunity to upcharge cases as felonies in an attempt to get bail. I think it happens already. I don't think that right now in Vermont, this is where I'm kind of lukewarm on this. I don't think that it's a big problem right now. This is kind of we sort of did our thing a couple of years ago, changed the bail law, and I don't see this issue of a lot of people being held on bail for misdemeanors as a major issue in the system. It wouldn't be one of the top 10 if you said to me, list your top 10 problems in the criminal justice system. I wouldn't say bail for misdemeanors is the top 10.
This bill looks to get us to a point where there's no cash bail for any crimes. And I am sure you're aware that almost 200 people are held in our criminal justice system because they haven't posted bail.
Mhm.
So while I agree the scope of this bill is too narrow, because it does sound like it's only a small number of people that are being held on misdemeanors on bail, but it's a pretty large number being held on bail.
When you come back with that, I'll talk about that.
All right.
This one I think has some downsides for the system.
Okay.
Because I think you might be pushing cases into charging decisions that you wouldn't want to see.
Thank you. Any other questions?
Thanks.
Judge Zone.
Warm them up for me.
Yeah, it was everything I screwed up.
Good morning, Tom Zarnay, Chief Superior Judge. When I saw the bill, I made some notes right away, and one of the things I did check also was, Mr. Valerio mentioned bail appeals. In 2022, there were 28 bail appeals. In 2021, there were 31. 2020, there were 20. 2019, we had 12. 2018, 17, and 2017, 25 bail appeals. So he was right on target when he talks about the number of bail appeals. The statute changed, I believe, based upon an enactment in 2017 to have the $200 limit. And one of the things we've seen during the pandemic, unfortunately, is the people Mr. Valerio describes as just where they are, well, they're not coming to court. And so we have had a significant number of individuals not show up. Anecdotally, some judges have said they think it's about 30% of the people who may be cited for court have just not shown up when they're supposed to. After that occurs, the court would then generally issue what's called a cite release warrant. The court would say, arrest the person, give them a citation, let them know that we really need them there. Some courts will send a notice of hearing out again, hoping that people will respond. But then you do the cite release warrant, and the individual will hopefully come to court based upon the new citation. Then we have people who don't. And so what do you do then? So the issue that is before this committee in S27 to eliminate cash bail on these misdemeanor cases, that's a policy decision. And I'm not going to weigh into the policy of it. The impact of that policy would, however, likely mean that there will be a number of individuals who we're not going to be able to get to in certain dockets, in certain cases. It's just, that's what's going to happen. Because if you can't impose bail, what do you do next? If you say, well, pick them up and bring them to court, well, if you arrest them in the middle of the night, you can't bring them to court then. Are we going to say hold them? Well, there's no basis to hold them if there's no bail, or there's no hold without, whatever it may be. So it's a policy decision that will have a real world impact in the courts as far as people appearing. And again, when you have the Defender General telling you that they don't know where a lot of their clients are, those people aren't coming to court. And we're trying to find a way to get them to respond. And so if you go in that direction, I would note that, and I can get into the weeds on the statute if you want on some issues, but I don't know that you need that right now. Okay. As far as the section 2 on a proposal, as far as an evaluation, I heard some mention of the Sentencing Commission. Members of this committee, some may not know that I happen to have the privilege of serving as the chair of the Sentencing Commission. And so if the committee legislature thought that it was appropriate for the Sentencing Commission to take on a study, we would certainly be able to effectuate that, report back with what proposal in section 2 is looking at. If you feel that you want a separate committee, I would just note that as written, it doesn't set up a structure for who's in charge, who calls the meeting, who's in charge of getting the report. And so I think that it would be helpful if you went in a separate group to make sure it's very clear as to who calls it. Last year, there was when this committee set up the study on forfeiture, it was very clear. Basically, it was laid on my shoulders as chief superior judge to set the first meeting. We set the first meeting, we elected the chair, and everything was there. And I would just recommend something like that to make some clarity of the statute to how to go forward. Section 3 for collection of race data, no objection at all, that we would support that. And section 4 for notices of hearings. I think Mr. Valerio's testimony about the new process is a great idea that the Defender General is going to follow, and I would wholeheartedly endorse that. I think if we look at the judiciary right now, we have a lot of pressures. If it's something that could simply be the push of a button and we can put names in with defendants, that's obviously, that may not be a difficult task. If it comes up where we have to do a lot more data input to get that, or we have actually to send out letters because maybe people don't have telephones or email, that's going to take staff. But it seems that before, the way the statute's structured, it talks about, well, we're going to implement this, you're going to start doing it. And then you're going to tell us how you're going to do it with money. And I know that the time for implementation is 2025 and they wanted to report in 2023. I would suggest you don't need to take that jump in the first clause about you absolutely shall do this. I think if the legislature would like us to evaluate it, absolutely. We can come back and say, here's what the cost is, here's what the impact is, here's how we can do it. I don't know, and I checked, we would have to check with Tyler Technologies as to whether our technology can do what Mr. Valerio is talking about for text messaging. And that might be something that is minimal. And even if the Defender General is doing it, we could do it too. Belt and suspenders is always good.
Senator Booth.
Thank you, Judge. I'm wondering, we've talked in other hearings about the IT situation for the judiciary, and you have a proposal, currently in appropriations to, fund a transition away from ADS. So I'm wondering, does this represent some sort of additional burden in that transition phase?
I don't know that it would be, I think it's the issue of ADS is really the issue of, if you will, how we get the bandwidth, how we get to the server, and how the server sends that into the internet. This issue for S27 would be much more of what the system does. So I think it's probably a different issue, which means if there's a financial impact, it would be an additional impact beyond what we've already been talking about.
Understood. Okay, thank you.
Other questions for the judge? Judge, thank you very much.
Thank you.
Squinting because there's actually blue sky out there.
I thought it was the sun coming off my head.
It's unusual.
I was getting nervous.
Jacobson, Attorney General's office.
Good morning. For the record, Erin Jacobson, Assistant Attorney General and co-director of our office's Community Justice Unit. So our office supports any efforts that might make our bail system more equitable, predictable, effective and consistent. To that end, we would certainly support a task force or a working group to identify conditions that would be required to eliminate the use of cash bail. But I would also defer to my colleagues that testified before me. And it seems like it's not wise to completely eliminate cash bail, then that should also be an option for the task force to communicate. And I think the language regarding that task force or working group is a little bit narrow and maybe overly directive, because it talks about how we need to identify conditions that would be required to move toward the elimination of the use of cash bail, and then to develop a proposal to eliminate cash bail in Vermont. And so I would just say that after studying the issues and the possibilities, then the question might arise whether we want to entirely move away from cash bail and what that would look like. To Senator Rehofsky's good question about Illinois, I did have time to Google it. I don't know a lot about it, but it appears as though they, in their intention to step away from a cash bail system, they've also developed and designed a pretrial release system. And so maybe that's something that the working group would want to look at. But I would think that would need to be really carefully considered, carefully designed, and whether that might work here is a different question. We're not Illinois.
Well, if we're gonna look at other states, we should probably look at New York as well.
Yes.
Their experience, and how their experience is going. I know it's gonna become a real political football over there. but,
I'm sure it has. That's not
You
surprising.
know, at least we should be aware of other states. So I would add that to the study, whatever format we do is. I don't know if there's other states besides Illinois
There are.
and New York.
And many municipalities. It looks like Illinois, New Mexico, Washington DC, Alaska, and California.
But Illinois' elimination of cash bail is on hold while the Supreme Court, because the Supreme Court has determined that the elimination of cash bail might not be constitutional. So we have to consider policy issues as well as very serious legal questions. And so
The United States Supreme Court or the
Illinois Supreme Court.
I was gonna say other states have done this before, Illinois in some way, but you are right that you all have pretrial supports and services that I think are critically important. The Michigan bar actually has shown with their support that cash bail is no more likely to make someone show up.
Well, so all of these questions then should inform how we move forward. And I would just say that regarding Section 1 going into effect July 1st, 2025, that is before Section 4's C, which has the judiciary reporting to the General Assembly on the efficacy of the notification system. So it just seems to me and our office that we would welcome any kind of working group. I was sad to hear that my colleague, Mr. Tebow, doesn't want to have another working group with me, but I guess maybe we can do this at the Sentencing Commission that I sit on as well. But happy to discuss the issues, any ideas that would make our bail system more equitable and effective. But before we have that information, it doesn't seem wise to implement a move away from cash bail for all misdemeanors.
Any other questions? Thank you very much. Our next is Jessica Hartford from the Glass Network.
Can't hang out, that's a work.
Oh,
Good morning, Senators. Jessica Barquist from the Vermont Network. I guess I'm going to stick to the trend of starting with Section 2 and then kind of working backwards. So the Section 2, the work group, we were really grateful to be included in this list of stakeholders in the work group and really welcome the chance to be able to explore these complex issues further. Just to note that the network is not a part of the Sentencing Commission, and so we would really welcome the chance to be a part of these conversations and however it is formed.
Is the Center for Crime Victim Services, are they members?
They
I
are.
think they are, yeah.
Yeah.
So,
Yeah, but we are not. And we also hope that within that scope of work, that the work group will consider additional policy recommendations that might be required to better assess immediate dangerousness and risk within our criminal legal system and how to hold individuals accountable to their conditions of release. Section 3, we support this section. This data is really essential in order for us to have the full picture of pretrial risk determinations and how they're currently being made. And then we also support section 4 on the notification. We're always pretty supportive of increased notification for all parties involved in the legal process. It's complex and confusing sometimes. And we fully support making that process as navigable and accessible as possible for everyone. Moving back kind of to the issue of removing bail for misdemeanors. The network, we recognize the inequities and challenges that are inherent in the cash bail system, and we'll say, like, philosophically support its elimination. Cash bail creates and perpetuates inequities and disparities in our criminal legal system by creating circumstances where an individual's freedom is dictated by their ability to access funds. And we believe that that is unequivocally unjust and inequitable. And so we do recognize the need for bail reform more broadly, and just in general, the disproportionate impacts of our criminal legal system on BIPOC individuals and communities, as well as individuals who experience poverty. And as we've heard, the purpose of cash bail is to mitigate risk of flight. Cash bail is not intended to be, nor should it be, how we achieve victim safety. But it is a tool of accountability that is used when needed to get individuals to come back to court. And as that accountability tool, it does serve some positive functions related to victim and community safety. So in a domestic violence situation, the most critical time, the most dangerous time, is when that victim takes those initial first steps to remove themselves from that relationship. And oftentimes that can be precipitated by law enforcement involvement and some criminal charges. And that is that critical moment when we need to provide protections and resources to victims. And as a state, we currently don't have any systemic empirical ways for our system to assess dangerousness or risk of harm, especially in domestic violence cases. And while it is true that individuals can be held without bail when we talk about serious felony cases, we also know that the charged offense doesn't always necessarily correlate with the dangerousness of a particular situation. So it's very possible for someone who's charged with a misdemeanor domestic violence offense to pose a grave lethality risk to their partner. So in this sense, cash bail does promote victim safety. When an individual who has caused harm is held pending bail, that time, even if it's very short, can provide a critical safety window for a survivor to, as that individual is assessing bail funds and being processed by the court, the victim has a window of time to safety plan and to get to safety. And we have also heard arguments that well-tailored conditions of release can help account for victim and public safety. And these can be very helpful. However, in practice, these conditions vary widely based on the judge or the information presented during the arraignment. In addition, many offenders do not adhere to their conditions and pose sometimes life-threatening risk to victims.
Jessica, sorry to interrupt you, but
Yeah, that's okay.
just for the record, can you share with us how many homicides in Vermont stem from domestic violence situations?
Yeah, every year, about 50% of Vermont's homicides are domestic violence related.
What is that number?
It varies year to year. And
50%
so
don't tell me
the,
anything. What's the number?
the
Six.
Vermont is a small state. We have a very low homicide rate in general. And the Domestic Violence Fatality Review Commission reviews all homicides that are, you know, related to domestic violence. And they find on average since like 2009, I believe, on average, every year.
So let me
half of our
clarify,
homicides.
one's too many, okay? I just wanted the number.
Yeah, so it does make up a significant percentage of
Of
those.
all the crimes of domestic violence. It's high on the, I mean, when we looked at those 22 and under in the previous bill, the alarming number that were domestic violence related. And so was, and you and I didn't think there were that many under 18, you know, would be charged with domestic violence. It's a huge number
That's right.
compared to the number of crimes.
And law enforcement could probably speak to this better, but I know anecdotally from speaking to them that domestic violence makes up a significant percentage of their daily workloads. So kind of moving back to these conditions, it is extremely difficult for us as a state to assess adherence to those violations of conditions of release because we have no system of pretrial monitoring or any sort of pretrial support services. It is also incredibly difficult to get those violations of conditions prosecuted, even when they are directly related to victim safety. And, you know, the imposition of conditions and the need to take those violations seriously is incredibly important. And there are many cases where, you know, the criminal process and a civil relief from abuse process happen simultaneously. And because there are conditions imposed in the criminal process, the victim will choose not to follow through with the civil relief from abuse process, often because it puts them at greater risk of safety. And they rely on those pending criminal charges and those conditions. Or there are some judges who will deny those civil final orders of protection because those civil or the criminal conditions are in place. And so bail is sometimes that only tool that gets that individual back into court so that the courts can assess and address those violations and safety concerns. And without bail, there is really no other available tool to ensure that those conditions are being followed and that individuals are being held accountable for violating those conditions, which in a sense makes the ordering of those conditions a bit of a false sense of safety for victims. And so kind of all that being said, we cannot support the removal of cash bail for violent misdemeanors at this time. As we know, many domestic violence or even serious stalking cases are often charged as misdemeanors. But these individuals pose a serious safety risk to their victims and communities. And while, like, again, I totally acknowledge that it is an imperfect and inequitable tool, it is the only tool that we have available at this time for accountability. And so we just can't support removing the only accountability tool we currently have without first having something else in place that could account for victim and community safety and ensure that individuals return to court and engage in that process.
Any questions? Thank you very much. Michelle, can you come back on? I wonder, committee, I think we're going to have more testimony on this next week. I don't think I know that. But I wonder if it might make sense to go ahead with requesting the Sentencing Commission to look at this. And if Michelle could work with Senator, get it right, eventually, Kowalski. And Judge Zone on how to put that together so that it's something the Sentencing Commission can do and something that will get the information that the sponsors of the bill are looking for. Yes,
Erin Jacobson, Vermont Attorney General's Office. If we are going to task the Sentencing Commission with this work, could we also then make sure that the network is included and at the table for this discussion?
that would be, yes, that would be a good, that's, I don't know if you're willing to work with.
I'm more than willing to work with folks. I would love to see it be more than a working group for data and actually a working group to develop a proposal for pretrial release supervision so that we can end cash bail.
All right, whatever you, Michelle,
Okay.
and Judge Zone, and anybody else who wants to be involved in helping with this effort. I'm singling you out because you're the sponsor, one of the sponsors of the bill, as well as a member of this committee.
No, I'm happy to work on that.
I think section 3 is probably already in S14, but we can, if it's not, we can move it there.
Senator Sears, I emailed you, I checked in with Ben and he gave me the language that's in 14. It's more comprehensive than what is in this bill, but I sent you the language and you can, we can take a look at it. And if you want to just amend anything in 14, we can do that and then take out the section here.
And then, I don't know, we can discuss what to do with section 1 next week, in section 2.
Question for you. So as we were going, I was sort of compiling a list of people I think it might be helpful to hear from. What can we sit down and kind of go through that at some point?
Well, okay, we got scheduled some time. So we'll just get some names.
All right, will do.
10:45 next Wednesday.
10:45 next Wednesday.
And we have,
I will get some names.
what's her name?
Jen Pullman. Jen
I'm
Pullman.
sorry, Jen. Scheduled, because she couldn't be here today. You can fit in whenever you'd like. All right. Is there anything else on this bill? Thank everybody for their frank testimony, and good luck with your case management system, Matt. It'll probably be the first one in the state that actually works.
No, we